In the last exercise, we distinguished between primary and secondary authority. Now, in this one, we're going to distinguish between mandatory and persuasive authority. Now, mandatory and persuasive are categories that are a subset of primary and secondary. So, primary authority can be either mandatory or persuasive, depending upon the jurisdiction of the authority and the jurisdiction of the court in which you are going to cite the authority. Secondary authority, however, is only ever persuasive. Therefore, it doesn't matter what the source is or how credible or notable the author is, the secondary source is always going to be persuasive. This is so even if it's something that has been adopted into law. So, for example, the restatements or the model penal code have been adopted by certain states into their law. And so basically what's happened is those states have taken a provision from, say, the restatement of torts or the model penal code and adopted that language as their own statute. That doesn't make the restatement or the model penal code the law. It just makes their law based on the restatement or the model penal code. So the restatement and the model penal code are still not the law, but the language may be adopted by certain jurisdictions. So you've got a client who has been prosecuted in federal court for possessing marijuana with intent to distribute in violation of federal criminal statutes. Law enforcement officers found marijuana growing in the corner of an uncultivated field on her small farm in Grinnell, Iowa, which she inherited from her grandparents. Your client lives with his wife in the old farmhouse, which is surrounded by land. Your defense theory is that your client was never in possession of marijuana as defined by the statute because she did not know it was growing in the corner of the uncultivated field located a half-mile from the farmhouse. So you're told that your task is to determine whether each of the following pieces of authority is mandatory or persuasive primary authority. Second, for those you decide are persuasive, determine whether each one is highly persuasive, moderately persuasive, or slightly persuasive. Before beginning, you want to identify in which federal circuit Iowa is located. And so the easiest way to do that is just to Google federal circuit map and then look for Iowa and which jurisdiction it's in. So take a second to do that. So you should have discovered that Iowa is in the 8th Circuit. And so you see here the federal circuit map. Iowa is in the middle and up a little bit. And you see that Iowa is broken into two separate districts. There's the Southern District of Iowa and the Northern District of Iowa. And then all of those cases from the Southern and Northern Districts of Iowa get appealed to the 8th Circuit Court. If you look over to the East Coast on the map, you'll see the state of New York and where New York is. So you'll see that New York is in the 2nd Circuit, and there are several states in New York, and New York is divided into 4 districts. We've got the Western District and the Northern District, and then, in fact, what's funny is that the Northern District of New York is most of geographical New York. Then you've got the Southern District of New York, which is primarily Manhattan and Manhattan. And then you've got the Eastern District of New York, which is the geographical Long Island. And I say the geographical because Brooklyn is not part of the Southern District. Brooklyn is actually part of the Eastern District. So you've got an Eastern District courthouse on one end of the Brooklyn Bridge, and then if you walk across the bridge and go a couple blocks, you'll see a Southern District of New York courthouse. So that's how New York is divided. But back to Iowa. Iowa's in the 8th District. The 8th Circuit. So let's look at our pieces of authority and see whether we think they're mandatory or persuasive, and if they're persuasive, how persuasive they are. So you have a decision of the U.S. Court of Appeals for the Sixth Circuit interpreting the term possession as used in the federal criminal statutes prohibiting a felon from possessing a firearm. So here, to use the information we have from the sorting and selecting authority video, we have a case from a different circuit. Iowa is in the 8th Circuit, and so we have a different jurisdiction. We also have different law. We have the term possession as used in a different context. And so possession as used in the context of firearms has different purposes than possession as used in the context of drugs or prohibited substances. So you've got different different law, different jurisdiction. So this is only going to be mildly persuasive. Next, we have a regulation of the U.S. Fish and Wildlife Service defining possession for purposes of the Endangered Species Act. So again, is this mandatory or is this persuasive? This is persuasive. And so the question then is it highly persuasive, mildly persuasive, or only slightly persuasive? Well, a regulation of the U.S. Fish and Wildlife Service defining possession for purposes of the Endangered Species Act, possession here is dramatically different than possession in the criminal context of weapons or drugs. Weapons and drugs are at least both contraband, so they are going to have some similar goals in common, whereas possession for the Endangered Species Act is going to have very different goals, the goal of defining possession. So although the first one was mildly possessive, because at least they were both contraband under a criminal statute, the term possession here, this law is only going to be slightly persuasive. Next, a federal court rule determining whether a prejudicial statement by a criminal defendant is admissible against her at trial. This is mandatory authority. Now, whether or not it's relevant is a different question, but there are no degrees of mandatory the way there are degrees of persuasive. So it's either mandatory or it's not. It's a federal court rule, and a federal court rule in federal court is going to be binding. Therefore, this is mandatory authority. Next, we have a decision of the Iowa Supreme Court defining possession as used in state criminal statutes, prohibiting possession of marijuana with intent to sell. So here we have the situation of different jurisdiction, same law. And so this is at least mildly persuasive. You've got something that is not identical. It's not the same jurisdiction and the same law, which is the most persuasive. You've got a different jurisdiction being the Iowa Supreme Court. So your case is filed in federal court. This is in state court. So it's a state marijuana possession definition versus a federal marijuana possession definition. But it's basically the same type of law, and it's going to have similar policy goals driving its definition. So this is at least mildly persuasive. The fact that it's a different jurisdiction is what keeps it from being highly persuasive. Next, we have a published decision from a different federal trial judge in Iowa defining the term possession in a case involving similar facts. So a published decision from a different federal trial judge in Iowa. So we've got similar jurisdictions, but not the same jurisdiction. So we've got a trial court at the federal level. So that's going to be a sister court to the court that we're in. And sister courts do not bind each other. However, judges do try to make sure that the law maintains some consistency. So this judge might be somewhat persuaded by how another federal trial judge has ruled on something, but that judge is not going to be bound by it. So you've got the same law, but different jurisdiction. This one's going to be mildly persuasive. Next, we have an Iowa state criminal statute defining possession for purposes of prohibiting possession of burglary tools. So we've got a different jurisdiction. It's not the federal jurisdiction, it's a state court rather than federal court. And then we have possession in a different context. We're not talking about contraband like drugs or weapons. We're talking about burglary tools. So there are very different purposes for that. And in fact, burglary tools have valid uses. The things that you use as burglary tools are also tools for other purposes. And so they're going to define possession differently for burglary tools than they would for weapons and drugs, things that you're not supposed to, things that are prohibited from possession under any circumstances. So this one's only going to be slightly persuasive. Different jurisdiction, different law. Next, a North Dakota Supreme Court decision holding that a criminal defendant could not be found guilty for possession of marijuana without knowledge that the prohibited substance was either on his person or within the curtilage of his dwelling. So this is the exact same law, but it is a different jurisdiction. So it's a North Dakota Supreme Court decision, which is the highest court in the state of North Dakota. It's not binding at all on this federal court. However, the law is exactly the same type of law. So it's going to be somewhat persuasive, but it is in fact different law because it's a different jurisdiction and different jurisdiction. So we would call that one either mildly or slightly persuasive. Finally, a decision by the U.S. Court of Appeals for the 10th Circuit affirming a conviction of a Kansas farmer for possession of marijuana with intent to distribute in violation of the same federal statute after the local sheriff spotted a patch of marijuana growing in a corner of the farmer's garden. Very similar facts, the exact same law, and a sister court to the one that our case would be appealed to. So the 8th and the 10th Circuit are sister courts. So while the 10th Circuit doesn't bind our trial court, the court that does bind our trial court, the 8th Circuit, is going to take into account what the 10th Circuit does. So because we've got identical, almost identical facts, the identical law, and a very closely aligned jurisdiction, this one will be highly persuasive.